15 minutes, and the appellant may reserve up to 5. Thank you.
I'd like to reserve 5 minutes.
That's absolutely fine. Thank you.
All right, may it please the court, I represent the appellant, Shaniqua Jackson, and she's the mother of the 3 children that are subject of this appeal. Our first argument would be that the trial court erred in awarding permanent custody when there was an alternative disposition available. The High Revised Code 151.415A said permanent custody should not be considered until all other possible dispositions have been explored. And in this case, it became known to the trial court that there was a possible viable alternative to permanent custody, but Children's Services had not explored that option. I know Appellee argued in her brief that the court did not err because there had never been a motion filed for legal custody. We are not arguing that there was that was the error. We are arguing the error was that once the trial court became aware that Children's Services had not explored this other option, which was a relative, well, her children were cousins to appellant's children, that this person was interested in taking legal custody of the children, but yet Children's Services had not explored this option.
Well, they argue that an alternative to and say that even if they had filed a legal custody, I understand what you're saying. You're saying it's not about a motion for legal custody. It's a matter of whether there's another alternative available aside from permanent custody and that CSB didn't explore. But they argue that in the alternative, that even aside from that, about the legal custody motion and so forth, that this individual already had, I guess, like 2 kids of their own that were under age 5. This would be 5 under age 5, as well as the fact that she seemed more concerned with just accommodating mom than really being the custodial parent to the children.
Well, but she called Children's Services in January, and when they pretty much told her that they weren't looking for anyone to place children with anymore, she then pursued going through another organization, which she found out she couldn't get custody of the children through that because of it was only available to people 55 and older.
Right.
So it wasn't like she just said, I'm doing this. I mean, she showed that she was sincerely interested, I believe, in taking custody of the children. She had a...
If I may, though, if she was sincerely interested in taking custody of the children and maybe had been in custody since March of 2013, why didn't she contact the agency until January 2016, almost 3 years later?
Well, that...
Little kids. 3 years of their lives is the whole life of the youngest child and a significant portion of the lives of the other 2 children.
I mean, I really can't answer why she had not. I only know that once the case was remanded back and she became aware, I don't know at what point she became aware of all this, but she did ultimately step up in January and say, I want to take custody of them. She had housing, which was, she could accommodate the children. And she had a 4.0 in college, so apparently she was an intelligent person. She had no criminal history. She had no drug history. I mean, the point where she came forward, I'm not sure, at least in our opinion, is as important the fact that she did come forward and express interest, and she seemed to be a viable option, and that issue should have been explored. Because it's far better to have her children and Pelham's children knew each other. So I mean,
Some of them for some small period of time.
yes, we'll believe it. But still, it's better. There was some connection there, and obviously, if she had a suitable home, it would be better for the children to be placed there as opposed to with someone that had no family connections.
So, your brief indicates that this is a relative placement, and the appellee's brief indicates this is not truly a relative placement. That being germane to what lens we would look through in terms of what the agency was required to do, how would you respond to the argument that this is not truly a placement with a relative?
Well, it's a stretch, but the woman, Abigail Frazier, her children were cousins with the Pelham's children. So they shared,
Did the person who, did she reside with mother's brother?
Abigail? I do not believe so.
But the uncle, mother's brother, who was the actual uncle to these three children, biological uncle, never filed for custody or anything.
No.
So it's the cousin relationship that you are?
Yes.
Okay.
That's correct. Basically, again, as we were arguing, I believe that, we believe she was a viable alternative, and that Children's Services did not do a case study. They did nothing really to look into her. And that when ground permanent custody says it must be in the children's best interest, and until I think Ms. Frazier was explored as an option, you cannot say that permanent custody to Children's Services was in the children's best interest. We believe the trial court should have ordered Children's Services to look into Ms. Frazier as being an option to place the children before they granted permanent custody. Our other argument is that the trial court erred in finding that the burden had been met. They said that the children were abandoned, and we'd argue that that fact was not true. Appellant had been trying to visit with the children, yet they kept putting up roadblocks for her to see the children. First it says because she had a warrant, she took care of that. But again, that's in itself shouldn't be a reason for her not to visit with the children. And just as I stated in my brief, it seemed to be one obstacle after another they put up. And she had accomplished the 3 basic case plan objectives. And I know there was some back and forth. Her attorney had argued that they were more subjective than objective things she had to do, and they had met with Children's Services. And basically, if she'd been visiting with the children, we believe that she had done the basics. She'd gotten her mental health counseling, and at one point she headed to the housing at about the time of trial. She did not, but again, if this had happened back, instead of putting up these roadblocks for her, those objectives would have been met. So really, it appears to us that you're supposed to, as case law says, every effort to be made to prevent termination of parents' rights. And it appears that once the case was remanded back, that Children's Services wasn't really looking to try and send the children back to appellant. Instead, they were putting up obstacles to keep her from seeing the children, and thus, to say that she had abandoned the children is inaccurate, when in fact she was trying to see them. Ultimately, after meeting with Lorain County Children's Services supervisor, she did give visitation, but at that point, we were near the end of the case.
If we could back up to, the court made an alternate finding of 12 and 22. Do you agree with that?
I'm sorry?
Do you agree that the children were in the custody of Children's Services 12 out of the consecutive months out of the immediately preceding 22 months?
Well, yes, but as I said in my brief, had they not continually created the obstacles for appellant, we believe that would not have been the case.
Do you know what months we're talking about, what that finding is related to? Because I know there's an intervening appeal, so I just want to make sure we're all on the same page with what months, what 12 months we're talking about.
Well, the children were returned to, I believe it was June. It was in June that the case was remanded. Yeah, June 16th, the case was remanded back, and Lorain County Children's Services immediately filed for custody, emergency custody at that point.
June 16th of 2015.
Yes.
Emergency temporary custody.
Yes.
And that was granted when?
That day. The case was remanded back on June 16th, and with the next date, they filed on the 17th for emergency custody.
And when was the disposition for temporary custody?
Temporary custody was July of 2015. And the case came on for hearing on April 4th of 2016. So really, if you do the remand date, that's correct, it wasn't 12 months. But I believe they were going on the fact that the children hadn't truly, even though it was remanded back, the case had started.
They remained in physical custody of the department
Yes.
in the preceding 22.
Yes. So anyways, those are the reasons I'd ask the case be remanded back. Thank you.
Thank you.
Good morning. May it please the court, my name is Emily Kirsch and I represent the appellee Lorain County Children's Services. I'm going to address Mother's first assignment of error where she claimed that the trial court erred in granting permanent custody to Children's Services when there was an alternate dispositional alternative available. As an initial matter, the interested third party in this case was an interested third party and was not a relative. A relative is someone who is related by blood or marriage. The person that custody would be given to, Abigail, was not related by blood or by marriage, so she would be considered an interested third party. Mother claims that the trial court should have denied Children's Services' motion for permanent custody and ordered Children's Services to investigate Abigail. In support of this, the only statutory authority that Mother sets forth is 2151-415A. This is the statute that sets forth the dispositional alternatives. And this is the statute that allows a court to grant legal custody to Children's Services. Nowhere in the statute does it allow a dispositional alternative to order Children's Services to investigate somebody. Miss Abigail and Mother, Abigail could not be considered, however, because she never filed a motion. This court has held that where there is no motion seeking to grant custody of children to a relative, or in this case an interested third party, then the trial court has no authority to consider placing the child with that relative, or in this case an interested third party. Therefore, without Mother or Abigail formally notifying the court of Abigail's intent to become a custodian for the child, the trial court was without authority to consider her. If this court finds that the trial court did have the authority to consider her, however, the trial court did not err in denying the permanent custody because the evidence demonstrated that Abigail could not provide a legally secure permanent placement for the child.
And we'll stop you right there, at least I'll stop you right there. And I know you were attempting to address it, but I guess maybe I missed the point. Because what she's saying is, today anyway, is that it wasn't so much that the court didn't consider legal custody, it's a matter that CSB, upon being notified that she may be interested in custody, didn't do any type of home study or do any kind of investigation to see if she would be an appropriate placement.
That is true, Your Honor, that the agency did not do any home study. However, that is because through the conversations with Abigail, it appeared that she would not be able to provide the legally secure permanent placement, and there were two major reasons for that. The first was that Abigail demonstrated a lack of motivation and willingness to care for the children. Abigail testified that she knew the children were in the custody of Children's Services since 2013. She did not contact the agency until January 2016.
I understand that, I'm gonna let you make those
Yeah.
arguments. And so I apologize for interrupting you again, but I'm trying to figure out, I know she testified and all that was in the record of that, but are you relying on those arguments though to say that, how am I gonna ask this question? Is this hindsight being 20/20, meaning I'm looking at it now and going back and saying there was no reason to do a home study based on the evidence that was presented at trial? Or was that, did a caseworker come in and testify and say, I did not do a home study based on this evidence?
Both. I think that the main issue is that Abigail, in her conversation, she called the caseworker in January 2016. In that conversation, the caseworker testified that Abigail never fully came out and said, I want legal custody of these children. Instead, the conversation was more about how Abigail could be a support to Mother. She was more looking about how to be a support. The caseworker's view of this conversation is then corroborated by Abigail's testimony. When she was questioned, what is your ultimate goal in this case? She said her ultimate goal was temporary custody of the children so that she could help the parents get back on their feet because she wanted to be a stepping stone to the parents' future. That testimony, as well as what the caseworker testified, demonstrated that she really wasn't looking to be a permanent placement for the child. So that is why the agency did not do a home study on her, because the children had been in custody of Children's Services for almost 3 years when she called. And this was a situation where permanency was needed.
So it's my understanding that she was asked on the stand if she would be willing to take the children until they're 18, and she indicated at that time that she would. Is that the first time she ever said that she'd be willing to keep the children until they were 18?
Yes, Your Honor. And I will note that the trial court was able to observe the demeanor of the witness when she said that, and any reluctance that the witness would have set forth when she made that comment.
But if somebody comes forward and says that they are willing to take the children, doesn't CSB have an obligation to explain to them what that would entail? And that would entail keeping them until they're 18. And if somebody says, well, I'm just going to keep them until mom gets back on her feet, doesn't the agency have an obligation to say, oh, no, no, you're misunderstanding what you would be asked to do?
Yes.
Was there testimony in regard to the explanation that CSB gave?
Yes, and I believe that's what the caseworker testified to, was that the conversation was more about how she could be a support in temporary custody, and she was not looking for legal custody. And
I understand that, but what I guess I'm asking you is, what testimony came in as to what they explained to her?
I believe that the testimony was that the caseworker explained that they were looking for a permanent option for the child, legal custody or permanent custody. The agency was looking for a permanent option.
Did they explain what permanent custody meant?
I don't know if they explained what permanent custody meant to
meant to
Abigail.
So, I'm sorry.
Yeah.
Just seeing so many of these cases, it seems like so many people are confused as to what that means.
And
It's not technically permanent custody, we know that,
Mhm.
but a permanent placement, I should say.
yes, and I will say that I think part of the obligation to inform the court and Children's Services is on both Abigail and Mother as to their willingness to take legal custody, and I believe that's why the statute sets forth and why this court has held in the past that a motion must be filed, to make it very clear as to what they are seeking. Additionally, the testimony established that Mother never gave Ms. Frazier as a placement option until January 2016. The caseworker testified that when she received the case in 2013, she asked Mother for names of relatives and interested third parties, and Mother never provided that name. The caseworker testified that Mother was reluctant to provide any names. Additionally, Mother herself admitted that she never provided this name. Additionally, Mother claims that when Abigail notified Children's Services and spoke with Children's Services in January 2016, Children's Services told her that they were not looking at placement options. However, that is not credible in light of the fact that Children's Services evidence demonstrated that they were looking at placement options up until a week before the permanent custody hearing. Father provided the name of an interested third party 3 weeks before the permanent custody hearing, and Children's Services investigated that person and did a home visit with the guardian ad litem a week before. This evidence demonstrated that Children's Services was actively pursuing relative placement options. I would also like to point out that that Abigail would not be considered a legally secure permanent placement due to her lack of motivation, as I indicated. Additionally, she hadn't seen these children in 3 years. She admitted on the stand that she never asked for visitation of these children during that January 2016 conversation. To the children, after this long of a period of time, she was practically a stranger. Additionally, the testimony established that she would be unable to provide a permanent placement because she didn't really have the ability. The testimony established she had 2 children under the age of 5, so the addition of these 3 would make 5 children under the age of 5. She didn't really have a lot of family supports, as indicated by her bringing the children to the permanent custody hearing. Mother had to leave the hearing to watch the children. Abigail testified that she didn't have anyone to watch the children because she only relied on her mother or the children's father. The also concern about having Mother watch the children is Mother wasn't allowed to have unsupervised contact with her own children, so it called into question the type of decision she would make about who she would allow to watch her children. Additionally, Abigail testified that her only independent form of income was cash assistance in $525 a month, and she testified that she had her mother help her out with her bills. Her mother did not come to court to indicate whether or not she would likewise be willing to help out with the addition of 3 other children. This court has held that the issues of denying permanent custody and granting custody to a relative, or as Mother asserts, ordering Children's Services to investigate a relative, are really 2 sides of the same coin. Therefore, if the trial court found that it was in the best interest to grant permanent custody to the agency, then it was not in the best interest to grant custody to a relative or to consider another relative placement option. And under the second assignment of error, the manifest weight of the evidence did demonstrate it was in the best interest for the children to be placed in the permanent custody of Children's Services. When the trial court makes a permanent custody finding, it must find both prongs of 2151-414. Under the first prong, 2151-414B1, there are 4 conditions listed in the statute, and the trial court needs to only find one of the conditions. In this case, Children's Services proved 3 of the conditions. Children's Services proved that the children could not be placed with either parent within a reasonable period of time and should not be placed with the parents. By making this finding, it relied on 3 different E factors. The first E factor was that the parents failed to remedy the conditions that caused the children to be placed outside of the home. As to mother, there were 3 case plan concerns. The first one dealt with parenting. That was on the case plan because of the injuries that the child suffered, the middle child suffered when the agency became involved. The testimony established that although mother did a parenting class, she never implemented the parenting techniques that she had learned. Additionally, she hadn't visited the children very often, so she couldn't demonstrate an ability to parent the children. The next concern was with regards to mother's mental health. She did engage in counseling for a short time in 2013. However, after she disengaged in counseling, there were more instances of her mental health and aggression and violence that had led to altercations between her and individuals that had also led to criminal charges. Therefore, mother had been unable to demonstrate an ability to control her aggression. She also failed to demonstrate an ability to meet the basic needs of the children. Mother was evicted from her home in December 2013, and she did not get housing independently after that. She was living with the maternal grandmother, who mother admitted was not an appropriate placement. Based upon this, Children's Services proved that mother failed to remedy the conditions. Additionally, Children's Services proved that mother demonstrated a lack of commitment. The evidence under this E factor 4 also goes to E factor 10, which is abandonment, and then also one of the 4 conditions under 2151-414B1B, also abandonment. The testimony established that mother was offered visitation when the children came into the custody in September 2013, or in April 2013. She visited consistently until September 2013. After that, the visitations were at the agency because mother had no electric in her home. Mother's visitation was inconsistent during that time. Once the permanent custody was granted on July, I believe, 14th, 2014, the visitation stopped. It resumed again then when the permanent custody was reversed and sent back down to the trial court in June 2015. At that time, mother was offered weekly visitation at the agency. She visited on July 28th, 2015, and then did not visit again until January 2016. Visitation was offered from that time until December 2015, when mother agreed to suspend her visitation due to concerns about her mental health. Additionally,
record regarding that agreement, there seems to be some discussion about mental health counseling being needed. What is in the record of this case about that agreement not to visit?
the agreement was mother and the caseworker had a meeting in November 2015, and at that time, during that meeting, mother became very escalated. Staff members had to come in to make sure that the caseworker was all right because of the aggressive behaviors that they were hearing. At that time, mother appeared to the caseworker to understand that she needed some mental health counseling, and she agreed to suspend her visitation until she could engage in counseling. However, that case plan did not go into effect until December 2015. So from November 2015 until December 2015, she was still offered the weekly visitation. She did a mental health assessment, I believe in the beginning of January 2016, and the visitations resumed shortly thereafter. I would also then like to address the 12 of 22 finding that the trial court made. So under 2151-414B1D, the statute is that when making a 12 of 22 calculation, it's not necessarily the previous 22 months, it's just a consecutive 22-month period. So the children in this case must have been in the custody of Children's Services for over 12 months of a consecutive 22-month period.
Not the most recent.
Not correct, Your Honor.
Which is why I ask, and I'll ask you, what 12 months and what 22 months are we talking about when the trial court makes that finding?
I think in this finding, for the older two children, they were adjudicated on May 22nd, 2013, and then they remained in the temporary custody of Children's Services until July 14th, 2014. So you have it there. I think there's a couple different ways you could look at it to make a 12 of 22, but you have it there. Then for the youngest child is where you kind of have to add things together. And because that child was adjudicated October 23rd, 2013, remained in the custody till July 14th, 2014, and came back into the custody of Children's Services on an emergency basis on June 15th, 2015. And I believe you can use that date for the calculation to start the clock, because the 12 of 22 calculation is the earlier of the date that the child is adjudicated. And so since you already have the previous adjudication from October 23rd, the June 15th date starts the clock.
Is that a different case? Does it matter if it's a different case?
The statute does not appear so. The statute that sets forth is 2151-413-D1, and it doesn't indicate anything about it being a separate case. And I would note for the record that this actually was all filed under the same case number, so I don't know that that matters in this case. So based upon the evidence, Children's Services proved both prongs of the permanent custody statute by clear and convincing evidence, and therefore the trial court's decision was not against the manifest weight of the evidence.
Thank you.
First, we'd argue or reiterate that we believe that Abigail was a relative due to the fact that her children are cousins with appellant's children. And I did argue in my brief that the issue that we are not arguing that they should grant legal custody to her at the hearing. The argument is that they should not grant a permanent custody until it was looked into the fact that there was a viable alternative, in this case, Abigail Frazier. If you look at the transcript, the caseworker, it appears, made a decision that Ms. Frazier was not a viable placement on her own. She testified that she felt that the children, she testified she felt the children needed permanency, and so basically because of that, she didn't pursue Ms. Frazier. Ms. Frazier states that she, as she was told that they were Children's Services no longer looking for placements with family, but the fact that the caseworker says she felt the children needed permanency indicates that in fact she probably did tell Ms. Frazier that, because in her opinion, she didn't think Ms. Frazier was an option. So basically, we would also argue that that you can't really say whether or not she was a good placement or not, because she wasn't looked into, and that she should have been given at least that option should have been explored. It wasn't the caseworker's position to decide whether or not Abigail Frazier was a good placement for the children without looking into it. And as far as the issue is the standard, the manifest way of the evidence, we would argue that mother did meet her case plan objectives. As far as the parenting classes, the appellee argues that she did not have a chance, that she never implemented that. Well, that's because she never got the children back. How could she implement the parenting plan when she didn't have the children? She didn't visit the children because there were obstacles put up for her visiting the children. First, they told her she had the July visit. Then they told her it was a warrant for her arrest, so she couldn't visit. She took care of the warrant. Then she was told that she had to call an hour before her visits, and which she said was hard to do because of her work schedule when she was working. And then they amended the case plan that she needed to get a mental health assessment in October, which hadn't been part of the plan. And they told her until she had that, she couldn't see the children. So they continually put up obstacles for her seeing the children or visiting with the children. So we would argue that, again, that it wasn't her fault that she couldn't implement these plans or visit the children. And in addition, she testified that she was in the process of obtaining housing. So the fact that she did not have stable housing at the hearing time, she had applied for it and was going to be approved for it, she testified.